Morning, I'm Ann Foster from Richards, Layton and Finger, and we're here to talk about another one of the cases for the Oral History Project, the Revlon case. Gil, could you just introduce yourself?
I'm Gil Sparks, and I argued the Revlon case for the appellant in the Delaware Supreme Court.
And could you just tell us a little bit about your background before that case came along?
Well, I became a partner at Morris Nichols in 1979, just at about the time that all of this takeover activity, of which this was a part, began, and was fortunate enough to sort of build a reputation that allowed me to be a player in probably 75% of the major cases that came down between 1980 and the mid-90s, and this was one of the important ones. Unfortunately, it's not one of the ones that I won, but it nonetheless was an important case and an interesting one to talk about.
So one of the things I wanted to ask you about before we got started talking about this case is, I know that you had served in the military before you went to law school, and I wondered whether you thought that experience had any impact on how you handled litigation. And I'll tell you that, I don't know if you know this, but a nickname that sometimes people used about you was General Gil, because you were really good at organizing a team of people and getting them to work on a case. And I just wondered if that was something that you thought had any impact on how you litigated cases.
Probably did. I was a Coast Guard officer. I had a year's service in Vietnam. All of my service was afloat, and I had increasingly responsible positions, which sort of made some of the positions that I later had in the practice of law perhaps easier, because it was a leadership function that you were performing there. And there were a couple of takeaways I had from that I think affected the way I practiced. One was in the Coast Guard, you appreciated when the captain would stay aboard when you had an issue, rather than go home and leave it to others. And in these takeover matters, which were, for reasons we could talk about later if it's of interest, be due to technological deficiencies compared to the way things go today, they were almost wholly apart from the fact that they were on very, very tight schedules, as you could see in the Revlon case. They invariably caused you to have to be in the office until 4 or 5 in the morning to get a brief out the next day when you had something to reply to that you had 36 or 48 hours, just because you couldn't turn documents around with great speed. And I always felt that I wasn't going to leave the office until the last associate left, no matter what the situation. So that was just one of the sort of team-building things that I believe I took away from my military experience. And yes, I do think that caused one to be an organized person. You had to be organized in the military, or it could cost lives. Here it could only cost billions of dollars. But it was something that I do think it was one of my strengths. And also giving as much responsibility as you possibly could to the younger folks. None of these wins that I had, or for that matter, losses, were just on my ticket. I'll take responsibility for all the losses, but all the wins were the product of a team, as you know from the way these cases are done. And some of those team members are still practicing, and I take great pride in the success that many of them have had over the years.
I know from working with you on other cases that I always noticed that you were very focused on what it was that we had to accomplish and get everyone to work together to accomplish a goal. So I thought perhaps your military service had some impact.
I think it probably
on that.
did, yeah. And also I was older. I was a little bit older when I started practicing. And I also thought that the fact that I had less hair as time went on also helped, because people thought I was even older than I really was.
So let's get ourselves into the context of the Revlon case in terms of time. So 1985 was obviously a year where you probably didn't get much sleep. In January, the Van Gorkum decision came out. The day after that, you got a decision in Weinberger after remand.
Right.
And actually, I saw that 2 weeks after that, you had a preliminary injunction proceeding in Morton Thiokol. So even early in the year, you were very busy. Then obviously, as is being discussed in another video, April and May, you were very busy with the Mesa Unical case.
Correct.
So how, with that context, did you end up becoming involved with Revlon, with the client, and this particular matter in 1985?
Probably have to ask our friends at Wachtell Lipton that. I don't know who was available, but I had generally, I think, during this period been their first choice. Now, obviously, there are conflicts, and people end up being chosen and are unavailable. But I think at that time, the Wachtell Lipton people generally hoped that I was available, and if I could, I would work with them. I enjoyed working with them. So that's probably how this came about.
And so what do you remember about your first involvement with this matter?
You know, I really don't remember much of anything before the preliminary injunction hearing. I mean, I've gone back and looked at the docket, but I just, with this much passage in time, I really couldn't tell you whether people were, I don't even know if I was being consulted on some of the tactical decisions that were being made. I was obviously being kept up to speed as to what they were, because I would have been, at the trial level, an integral part of the briefing team, and then later at the appellate level, both on the briefing team and making the oral argument. But that's really all I recall. I do recall, and I have had a chance to go back and look at the oral arguments in the Chancery Court, and they did bring back some recollections of what was happening there.
So just to give you some dates, there was litigation first filed in district court by Revlon, and then a few days later in Chancery by the other side. So were you part of the conversations about choosing the forum and whether it was important for Revlon to sue first, or?
Don't remember.
But you were involved when you filed in the district court, and as I understand it, it was Judge Farnan's first takeover case. That's what he told.
I would not have recalled that, but nor do I recall much about the district court case.
Because the district court case ended up later on not being the primary.
Not being right.
And so you had a preliminary injunction motion that Revlon moved for in the district court, and you had a hearing in front of Judge Farnan, and then actually the very next day he ruled and denied the injunction. So a few days after Revlon had sued in district court, the other side sued in Chancery, which ended up being really the main battleground. So over the next several weeks, Pantry Pride kept, upping the bid just a little bit here and there.
Well, they actually upped it materially over the next couple of weeks, because if you recall, it had gone from 47, and then there was or 47.50, and then there was the stock issuance the note issuance in return for about 10% of the stock. Their offer went down to 42, but then without any other counter offers they got themselves up to 53 before Forceman Little got into the picture.
And so what was your involvement other than the litigation front? Were you going to board meetings at all during this time period for Revlon?
On this one, I don't think so. I don't have a recollection of going to board meetings. I did. There were some before and some after where I played both roles, but I don't remember attending board meetings on this case.
So then, we get to October 3rd, Forceman Little and Adler and Shaken are involved. Right. We're now up to $56.
Right.
And at some point around that week, Perlman tells somebody that no matter what the bid is, he's going to top it by 25 cents. Do you remember that?
Yeah, I do remember that. I mean, that was his topping strategy. That's what he said he would do. And
did you all think that he would really do that? Or did you think that was something else?
I think people thought that he probably would do that. I mean, I don't know if he would have done it at some level, theoretically. I'm sure he would not have done it. But at least in terms of a strategy at the levels that we were at, I think people thought probably that would happen. Now, nobody knows for sure. I mean, that's just it. And I'm sure the board had no idea. I mean, the board was aware of that, of him saying that, but I don't think they necessarily knew precisely what would transpire at what levels. How could you? Yeah.
And so the Chancery case had been assigned to Vice Chancellor Walsh,
Right.
who had been nominated to the Supreme Court but not yet sworn in. And I guess during the proceeding, he was sworn into the Supreme Court but remained hearing the proceeding.
I didn't remember that, but that's an interesting factoid.
So when you got to the point where there was a motion to dismiss or stay the Chancery litigation in favor of the district court, and Justice Walsh denied that and said we're going forward in Chancery. And then you have depositions. Were you involved at all in defending or taking any of the depositions?
I don't think so. I have no, let me put it this way, I have no recollection in this case of having been at any of these depositions. And the few that are mentioned in some of the back and forth in the papers don't seem to reflect the idea that I was there. I know there were some contentious depositions in which one side walked out and the phone call was made, and the other side walked out when they were simultaneous depositions, I guess, of the CEOs. I don't recall being involved in that.
I was going to ask you about that because, as I understand it, and I just happen to know, it was a Friday, October the 11th, Bergerac was being deposed and Perlman was being deposed, and supposedly Herb Wachtell felt that Perlman wasn't really answering questions, and so he terminated the deposition, and that both depositions were terminated.
Right.
Was there any thinking about anybody calling the court about that?
I don't know, because I don't believe I was there. I think those were, I mean, if you look at the schedule of when these depositions were happening, vis-a-vis when the argument was scheduled, and I think that the argument was on the 12th, was the argument on the 18th.
The argument was on the 18th.
The argument was on the 18th. But we were getting, we were into briefing mode by that time. I think I was probably more involved in working on the briefs than in one of these depositions, and somebody, and they were all in New York, so.
And looking back to that time, of course, we weren't getting email transcripts where you got everything immediately.
No.
The transcript would have to be sent to you. You'd have the person who attended the deposition come back on the train, tell you the major points so that you could start weaving it into the brief.
Exactly.
And then you wouldn't have the citation for another day or two until you got the hard copy.
Precisely.
So it was a different time in terms of what your involvement had to be, depositions versus briefs. So let me ask you about Simon Rifkin. He was, to remind you, on both boards until August the 18th, of MacAndrews and Forbes and Revlon. And looking back at that from, all these years later, it's hard to imagine that one person could have been on both boards and stayed on until the day before the first case was filed. And then he resigned from MacAndrews and Forbes.
It's interesting when you go back and read the record. Nobody makes much of that.
No.
Nobody makes anything of it at all, as a matter of fact. There is some deference paid to Judge Rifkin. And there's some reference to, somewhere in the record, to the fact that he was also a friend of Pantry Pride. Nobody makes the point that he was on the board of the controller of one, and at the same time that he was on the board of the Target. And it's just interesting. I think it goes to the respect that people had for him.
And so you don't really remember anybody on your side worrying about what impact that would have in the litigation?
No, not
I mean, it's interesting. Not one participant has really remembered anything much being made about it.
I don't remember anything about that, other than I do recall having looked back at the oral arguments in preparation for this session, that even Herb Wachtell went out of his way to say how much respect he and everyone else in the New York bar had for Judge Rifkin.
So the depositions are going on, and then we have the two principals being deposed in those depositions, and quickly that day. And it turns out that Forceman Little had that same day asked for a lockup. So on the Saturday, October the 12th, the Revlon board meets and decides to give the lockup. And I gather from what you said earlier, you were not at that board meeting.
I was not at the board meeting, or if I was, I don't recall it. Let me put it that way.
And so then on Sunday, the 13th, this gets announced, and then things which already were operating at pretty high speed
Right.
move into even
Higher speed. And so people were preparing for one set of facts, and then, as you could see, a whole different set of facts arise, and all of this has to get briefed in an extraordinarily short period of time.
And so you had a hearing already scheduled for Friday, which now has to take into account new facts, but there weren't going to be new depositions.
That's right. So most of this record was on affidavits, and you'll see references to those. And I think in the end, you don't get the sense that the result would have been a whole lot different if you had had depositions. I think the contested facts were on the margin of this. It really did end up turning out being primarily a legal issue when it was all said and done.
I was going to ask you about that because we often have cases where what happened is the primary focus, but here there wasn't really much dispute about what had happened.
Right.
Especially since you had the long minutes, the Rifkin affidavit, which was probably the longest affidavit I've ever seen. So people were fighting, as you say, about legal issues and not about the factual
Right.
issues. So on the Monday, the 14th,
With one exception. I mean, there was this question, which I guess is a quasi-legal issue about motivation in terms of the independent directors and their decision to insist on the notes being made whole. And I guess you could call that a factual question, but it was more important. It turned out to be more important to Judge Walsh than it did to the Supreme Court.
and let's talk about the notes for a moment. So what do you remember about the feedback that the Revlon board members were getting from the note holders?
Not much more than appears in the record. I mean, it was relayed to me that I mean, these are not notes that you find listed on some exchange. It was relayed to me, though, that the value of the notes in terms of how they had traded had suffered because of the leverage that would be put on Revlon by either Forsman Little or Pantry Pride, depending on how this turned out, and that therefore the notes were less valuable than they were before the board signaled that it would be waiving the covenants that basically said that Revlon would not take on additional debt in a material nature.
And I think there was something made about the fact that some of the outside directors had their own counsel to talk to them about the notes.
Yeah, and that seemed to be of some importance to Judge Walsh. But I think the record was pretty clear on that. That at least I believe it was Glucksman had his counsel there, as he apparently did any time he got involved in these takeovers, and he had his counsel there back on October 3, before the concept of changing the notes had really come up.
So you
And again on the meeting on the 12th, but it wasn't like it was. I think the record was pretty clear that accompaniment of counsel was not because of the notes. It was just he was going to have counsel there, personal counsel there, no matter what, throughout the process.
and it wasn't just because it was this case, that was what he would do.
And even he had done it in other cases, the record indicates, and in this case, it was actually, I thought, somewhat significant that to blunt that issue, that he had had counsel there on the 3rd before the note issue had become an issue.
So the other side moved for a TRO. You had a TRO hearing, and during that TRO hearing, I gather, the other side and the court found out that the assets had already been put into escrow. What do you remember about
You
that?
know, I saw that. I don't remember much about that, other than it didn't seem to make any difference in the end, because there must have been a representation that, well, they're still reachable by the court, and so the TRO sort of became. I mean, there was a TRO issued, and yes, it had already happened, but it sort of became a so what by the time you got to October 12th. People weren't making a big point of that anymore.
So that was on...
Or I'm sorry, by the time you got to October 18th,
Yes,
that's
right.
the argument, right?
Yeah, so you have a TRO hearing on Tuesday and then a preliminary injunction hearing just 3 days later on October the 18th.
Right.
So at the time of the hearing, Forceman Little was at 57.25, Pantry Pride was at 56.25.
Right. I think they went to 56.25 like the morning of the hearing. It literally happened.
So
I think it was on the day of the hearing. They went to 56.25 in the morning, and then after the hearing, after they had heard some concerns from Judge Walsh, which we can get into, they went to 58.
So did you think during the hearing, since their price was lower, did you think that there was any reasonable chance that he was going to enjoin?
Let me just tell you what I think I thought, and this is colored a little bit by having gone back and read the oral argument transcript. Judge Walsh was concerned and expressed his concern at some point about granting, it was sort of strange, he expressed his concern about granting the lockup and allowing the 56.25 offer to proceed, as distinguished from enjoining the lockup and allowing negotiation to go forward. And one of the unusual things in the hearing was that Pantry Pride had not really asked to enjoin the no shop. It wasn't really a no shop; it was a no negotiate provision that was in the deal, and they really hadn't asked to enjoin that, and they didn't ask because really they wanted just the judge to clear the way for their $56.25 offer to go forward. And Mike Mitchell got up, and he's the corporate guy. The argument was being made by Stuart Shapiro, and Mike Mitchell, the corporate guy, gets up and basically says, well, we'll consider our complaint amended after he heard the concerns of Justice Walsh. We'll consider our complaint to be amended to also ask for an injunction against the no negotiate provision. Because he was sensing, and Walsh said it, he said, I have problems with this if what you're asking me to do is simply to clear the road and allow your 56.25 offer to go forward. And of course, ultimately, in the end, he enjoined everything, including the no negotiate. But I think the other side, it wasn't so important what I sensed, but I think the other side sensed that they may well not win this if they don't put a higher offer on the table. That it was going to be really hard for Judge Walsh to, in effect, facilitate what was a lower offer. And there was a lot of back and forth about whether 57.25 with the time value of money, because it was going to take Forceman Little a little bit longer to get its act together and in terms of the merger documents, whether that was really larger or smaller than 56.25, which in theory Pantry Pride was saying it could do immediately. I think the record basically showed that there was that 56.25 was modestly higher. I would have been concerned. The other thing, of course, that's surprising about all this is that the issue that Revlon is famous for wasn't, until the very end, wasn't really what was being argued about. And we can talk about that as time goes on. The other thing that I found really notable, and of course I remembered generally that we had relied on the concept of that the amount, and it's not really paid to note holders, but in effect the cost to either buyer of making the notes whole, which basically meant raising the interest rate on the notes to take care of the added risk that they had greater leverage. I remembered that Herb Wachtell had made that argument. What I didn't remember, and what really stood out in looking at the case below, is he not only made the argument, but he quantified it. And he quantified it as basically another $2.25 as in the value of the offer, which basically was saying to the court, we've got one offer here at $57.25 plus $2.25. That's $59.50 versus a $56.25 offer. And it wasn't until, and you could see that the transcript is about 130 pages long. It wasn't until page 116 of that transcript that Bruce Stargett got up, and he was splitting the argument with Shapiro. So we had three people who spoke. We had Stuart Shapiro. He speaks. Mike Mitchell gets up in the middle of his argument and sort of says, well, all right, we'll ask for that if Your Honor wants us to ask for that. And by the way, he also made the representation that they would also make the notes whole, which is sort of an interesting concept of being the sort of part and parcel of what ended up being a breach of fiduciary duty on the buyer's part. And then Bruce Stargett sort of has this add-on role. And at about page 116 of a roughly 130-page thing, he hits on the idea that, gee, maybe there's something wrong with this idea of not giving that $2.25 to the stockholders as distinguished from giving it to the note holders. And we can talk about the Supreme Court argument, but I think it all, in hindsight, it might appear one way, but I think what was going on, and it'll be interesting when you interview the other side on this question. I don't think, given the language that had been in the Unical opinion about other constituencies, they weren't putting that argument up as their first argument, not even really their second argument. It was almost an afterthought. But Bruce did make that argument, but it was very, very late in the game. It was on reply in the oral argument. And of course, that became the corner piece of the Supreme Court's ultimate decision. But that, my main present sense impression with it, before I looked at the transcript and looking back 32 years, was, Wachtell Lipton and Herb Wachtell had taken a position, a legal position, and indeed Marty Lipton advised the board on this. If you go and look at the record, that it was appropriate in the takeover context to consider the interests of other constituencies, and these note holders were another constituency, and he had all the reason to say that because of what the Supreme Court had said only months earlier in Unical. And I think that Skadden was probably just as concerned about that issue and whether and that language and how the Supreme Court would react to that. I mean, we now look and we all know what Revlon stands for, and it stands for the fact that if you're at the end of an auction, or you're in an auction and that's the role you've taken with a sale of a company, a breakup of the company, that your only concern is got to be get the best price for stockholders. But nobody knew that at the time, and indeed the latest pronouncement by the Supreme Court pointed in the other direction.
And going to that pronouncement, looking back at the Unical opinion, the court says this entails an analysis by the directors of the nature of the takeover bid and its effect on the corporate enterprise. And then it says that examples of such concerns may include, and it says, the impact on constituencies other than shareholders, i.e. creditors, which is what they were hanging their hats on in that comment.
Well, that's right. I mean, that's what they said. And of course, that was a Lipton and Brownstein article. And don't forget, this is at a point in time in the bigger picture when Wachtell Lipton is the champion of trying to get states to put other constituency statutes into their law. Delaware never did that. But it was an issue, and it was one that institutionally Wachtell Lipton had taken a position on. And then, of course, a favorable citing of a Lipton article that makes that very point in the biggest decision that had come down in a decade, only months before, completely understandable why not only would there be no sort of no reluctance, or why there was no reluctance on the part of Herb to actually quantify it and make a big point of it, so that it made it look like a $59.25 or $59.50 offer against a $56.25 high low court. Now, of course, once they go to 58, which they did immediately after the hearing, then that issue that had been raised, including the 59.50 type argument versus 58, becomes much more important, because if you knock out the 225, then the 58 is clearly higher than 56.25. And the dynamic of all that, and how some of these strategic moves were being made to the court is distinguished from to the board, almost to the point where at one point there's a back and forth in the argument where they, I believe it came up in the Supreme Court argument, where there had been a comment, I think, by Stu Shapiro, telling the court, "Well, you're really the decider now, Your Honor. This is in your court." And we came back at some point. I don't know if I did it but our side did it, saying, well, "Wait a minute, that's for the board. That's not for the court. That's a business judgment as to which offer is higher." But the whole way this developed, almost as the facts kept changing, and they were changing in the courtroom. It was in the courtroom that Mitchell got up and said, we'll match the saving of the notes. Whatever Forstmann Little does, we're willing to do. And by the way, we amend our complaint here to ask for the no negotiate be knocked out. And they were doing that in response to a concern that Walsh was expressing, that, gee, I'm not going to just give you this at what appears that might be a lower price. I'm also signaling the fact that maybe I am willing to give you this, so that you can have a negotiation, and the negotiation can continue. But I'm not going to be the one to cut this off if there's more discussion to be had, which was obviously the right decision. I mean, we did end up at 58 rather than down at 56.25.
And we've learned in other interviews that people were leaving the courtroom at 15-minute intervals and calling back to Pantry Pride to report on what was happening in the courtroom, which is why
doesn't surprise me.
Which is why the 58 came out so quickly after the hearing.
After the hearing, right?
So.
And there was another little sidelight, another case I had been in. I can't remember any of the details of it other than what I read about it in this case. But in the N-Star case, there had been a sort of a change in price after the argument. And in that case, Vice Chancellor Hartnett said, no, we're testing the director's business judgment based on what they had before them at the time they acted, and that doesn't count. Here, obviously, it ended up counting. And I'm sure the Supreme Court was more comfortable doing what it did when it had a $58 offer out there that was indisputably higher than 56 or 57.25, and probably even a little higher than that, because there was some time value of money discount to be applied to the Forstmann offer. Probably not a full dollar that the other side would be arguing, but some discount.
So you had the oral argument on the preliminary injunction on October 18th, and then 5 days later, the injunction is handed down on October 23rd. Right. And between October 23rd and the 31st, everything happens in the Supreme Court.
Right. You go get an interlocutor. You get the court to hear it. Then you get a briefing schedule, and everybody prepares these briefs that come in, which were, I think the reply briefs were like 60 or 70 pages. I mean, these briefs are long.
And you did simultaneous opening and
And
simultaneous
simultaneous
reply,
replies.
the 28th and the 29th, and
Yes.
then you're making the argument the 31st.
The 31st, right.
And so you've been doing nothing but
Right.
tearing apart what happened in the Court of Chancery to try to figure out what to argue on appeal.
Plus whatever else my other clients who were being taken over were doing at the time. But yes, that's right.
So as you were preparing to make that oral argument in
Right.
the Supreme Court, what did you think were going to be your best points for the appeal? What did you think about the Unocal other constituencies argument?
I thought we had the better of that just based on what the Supreme Court had said. And at this point in time, nobody knew where Delaware was going to come out on this, but you knew what the Supreme Court had said only a few months before. Now, if you look at the argument in the Supreme Court, I didn't do what Herb had done. In other words, I didn't quantify it. I didn't say this is worth $2.25. Our argument was more, look, you got to judge everything by what the board had in front of it on October the 12th, and it had a 57.25 and a 56. And my primary argument was that if the board hadn't acted at 57.25, then the other side was going to get it at 56. It wasn't, you didn't have a choice of, so that was my argument, that this Forceman Little said, I'm not going to be a stalking horse, take it or leave it, 57.25, we want the lockup. And if we hadn't acted, then the 56, and by the way, everybody had already decided that the rights plan was out the window. So they could have gone forward, but for the lockup, and taken the company at 56. We did 57.25. It was rather clearly better than 56. Maybe it was 50 cents better, maybe it was 75%. But we were at the end of the process. It was pretty clear at the end of the process, and that was good. And then I went on to deal with this other issue, and it was the second thing that I started to argue. And this is the one I have the clearest recollection of. I've looked at the transcript. It's not quite as crystal clear. Let me tell you how for 32 years I've thought about this. I go on and I say, and as to this other point, Your Honor, you guys just told us, 3 or 4 months ago in the Unocal case, they all knew I'd been in the Unocal case, so that it was okay to consider the impact on constituencies other than shareholders, including creditors. And what more ideal group of creditors could you possibly have than these creditors, some of whom, or almost all of whom, were stockholders 2 weeks ago. In fact, apparently, the presses hadn't even gotten, some of the people didn't even have their notes yet because they hadn't been mailed. So it's both. If there's ever another constituency that you could consider, this is it under the guise of creditors. These are almost quasi stockholders, and Drew Moore, and the way I remember it is that Drew Moore said, well, we didn't mean that. In which case, I sort of said, well, Your Honor, if accepting that, I will move on. I can't do anything about that. If you didn't mean it, I will move on to whatever my next argument was. Now, it turns out that the way it reads in the transcript is he didn't say we didn't mean that. He said we only meant that in the context of front-end loaded two-tier tender offers. Well, that's nonsense. That's nonsense today and yesterday and whatever. They said it. What obviously they really meant was we didn't mean it in the context of the auction type process that they then proceeded to outline. They didn't mean it in that context. But it was like somebody saying we just didn't mean it. And I look at it and say, well, what could I say to that? And I moved on. But that became, and if you, even in the Supreme Court, if you go look at the argument that was made in the Supreme Court by Skadden, this wasn't their lead argument in the Supreme Court either. This came up. This was a what I would call their second argument in the Supreme Court. This Revlon, this concept of diverting the $2.25 to the note holders constituted a breach of duty. And if you look at the other interesting thing about all this is the Supreme Court, well, one place the Supreme Court characterizes it as a duty of loyalty. The Supreme Court doesn't decide this the same way Walsh did. The Supreme Court did not decide this on the basis of the motivation of the directors. It decided it simply on the concept that it was a breach of the duty of loyalty to not pursue, to not in effect dedicate all of their efforts to getting the money, the extra $2 or $2.25 that Herb had quantified below, and getting that into the hands of stockholders instead of diverting it to note holders. And they really sort of duck the motivation question. I actually think, and I've gone and looked at the briefs again. I think we had the right side of the motivation question. I don't think anybody really thought that there was a lawsuit against the individuals. Think about that. There might be a breach of contract claim against Revlon itself, but it was a stretch to get to the individuals in terms of that. Maybe some stockholder after the contract claim could bring a derivative claim, but that was pretty far-fetched. And the disclosure claim didn't appear to have any legs to it. In other words, there was disclosure of the fact that the independent directors could waive this, and the record was very clear that on October 3, when the decision was basically made that they would have to waive, that they didn't. Or I'm sorry, when the notes were issued, they were still pursuing a sale of a company on a sort of whole company basis. There wasn't the concept that it would have to be broken up. Wasn't around at the time that the notes were issued, which would have been in September sometime. It was so the idea that they knew when they issued the notes that they were going to have to waive to facilitate a leveraged buyout, and both the Forsman Little deal and the Pantry Pride deal were basically leveraged buyouts. They didn't know that then, and I think the record was pretty clear about that. And that would have been a theoretical direct action, I guess, under the federal securities laws for fraud in the prospectus with respect to the notes, but that didn't seem to have any factual basis. So I think the Supreme Court was right to duck the motivation issue, which is the way Walsh went, and just to sort of lay it out as sort of a per se loyalty slant care violation to divert money to another constituency in an auction situation. I mean, that's really what the holding was in Revlon.
So Judge Rifkin at some point said that he thought there was a moral obligation to the note holders. Mm-hmm. Were you worried that that was something that would be the focus of a lot of questions by the Supreme Court?
I was prepared to answer questions that the Supreme Court had. I just never got that far because they pulled the rug out from under me before we even started the discussion. I mean, I turned to that topic, and right away they basically said, well, we didn't mean that, or we meant that only in the context of front-end loaded two-tiered tender offers. I said, well, there's nothing left to say. I mean, I had no basis. They were basically telling me that they didn't believe that you, for any reason, could favor other constituencies in this context.
I know you said at some point that you hadn't made it past page 1 of your argument. Justice Moore immediately started asking you questions, and
Well,
so you made your argument.
Yeah, I made my main argument. I mean, I made the other argument. I made that I mean, yes, he asked questions, and he's the only one who asked questions. I don't know if you've read the transcript,
read
but
the
he's
transcript, yes.
it's the other judges were it was McNeely, and there was someone there by designation, and they asked no questions that I can remember, but Justice
Judge
Moore,
Balick was
Judge Balick
sitting by designation.
and yeah, but that was okay. I mean, I thought I got the primary argument, what turned out not to be the way the case got decided, but the primary argument of look, this lockup was appropriate in this context because it was the only way to get a higher offer on the table, and otherwise the company would have gone for 56. And that was the argument. That was the primary argument that was sort of joined, and then all of a sudden, this other constituency thing, the Supreme Court got really interested in that, and of course that is the way Walsh. I mean, Walsh sort of went that way, and once the court said we didn't mean what we said in Unical, then obviously we were sort of dead. I don't remember. I do go on and make other arguments after that, but that was really the popping of the balloon. I can remember being deflated instead of saying, because I had other things to say. I mean, I was going to, as you just indicated, I was going to develop all of that. And once the legal framework was pulled out from under me by the very judge who had no doubt written it months before, or certainly had a role in writing it, that was the end of the ball game.
And he also asked you, I'm just looking at the transcript, he said, so the directors at that point found themselves in a bidding contest for the company in their role as auctioneer, isn't that correct? So did you have a reaction when he asked you that question? Did you get a sense that that was where he was going to be going in the opinion? Or does it have only more significance
I think that may have
later?
been before he pulled the rug out from under me. I don't think, I don't remember. I don't remember. I mean, the idea of auctioneer didn't become important until the concept that you can't consider other constituencies in an auction-like situation became clear. When that became clear, I knew we were done.
So when the opinion came out, did you have any sense that we would still be talking about this 33 years later? I guess in a couple of weeks it'll be 33 years.
Yeah, it will be. And I mean, this comes up as recently as Senator Warren's draft bill that just became public. Where, I mean, it's all sort of an anti-Revlon. You've got to view the corporation as in this context or any other context as having literally a fiduciary obligation to other constituencies. I mean, that's what Delaware law said you didn't have unless there was a connection that you could link to the future well-being of the stockholders, which in 99% of the cases you can. It's only in this rare situation where you know that the company isn't going to have the same stockholders anymore that you can't make that linkage. But yeah, it's still an issue. It goes to the core of, in our system, of what you think the role is of a corporation. And I've thought about it. I've thought about it as recently as the time that Professor Hammermesh asked me to take a look at Senator Warren's bill. But it keeps coming up. It also is at the center of this movement toward, I guess I'll call them B Corps. It's the same issue, and you're right. And it was an issue. It was somewhat of an issue before Revlon, but Revlon really cast the issue into the limelight, and there's still people who disagree with it. I happen to think Revlon was probably right. But I think a lot of people have overread it because I also think you have tremendous latitude under the business judgment rule in any other context other than an absolute sale of the company or breakup of the company when you know that the same shareholders aren't going to continue. In all other contexts, I think you have tremendous latitude, and in some cases, and in many cases, maybe in all cases, if you do share responsibility to the stockholders, not to alienate your workforce, alienate your community, maybe even alienate the environment, because all those things blow back at you if you don't do it right and end up hurting stockholders. So this idea that a corporation, because of a case like Revlon, I mean, it's always true that you have to follow the law, but it's also true that most of the things that I just mentioned are things that it's in the interest of the stockholders that the corporation pursue and be viewed as positively as pursuing. If for no other reason, then you're going to start getting bills like the ones that Senator Warren has put out there.
Is there anything else that you'd like to tell me about your experience in the Revlon case that I haven't asked you about?
No, I mean, I do have a recollection that after Herb was unsuccessful in Chancery, that obviously a decision was made that maybe we're better off having a Delaware lawyer before the Delaware Supreme Court do this rather than an out-of-state lawyer, which was fine. But Wachtell Lipton over the years was very good at that. I owe some of my career to the fact that they had a view that our courts might be more receptive to locally grown lawyers, and grateful for that. But no, I think in this one, in retrospect, the die was cast before the Chancery hearing ever happened, if you look in retrospect and say the Supreme Court had in mind, or Justice Moore had in mind, a sort of a game plan, and that when you got into this auction breakup situation, you were in a different mode, and it's not illogical. I mean, it's not illogical to say that if you're in a situation where the benefit of dealing in a fairly or morally or any other way with any constituency, when that isn't going to inure to the benefit of your stockholders anymore, that then your job is just to get the best price you can for them. But it's not an illogical thing. It could have gone the other way. But I'm not sure if you would go the other way exactly where you end up. And don't think about that. You think about the context of other constituency statutes. They were pretty much out there to put an end in those jurisdictions that passed them to takeover matters, because you could rely on them to stop almost any takeover, because certainly anyone that was leveraged or had any real risk of meaning we were going to have fewer employees, or we're going to leave Bartlesville, Oklahoma in the case of Phillips, or any of these other social issues. And for Delaware and the way the law developed, it's probably the right decision, and probably consistent with the idea that we give the directors a ton of power, but also sort of on a down-the-middle approach to all of this. We also weren't going to put something out there that, in effect, could be misused to, quote-unquote, stop all takeovers.
You had said in your Supreme Court argument that having a sealed bid kind of auction really wasn't going to work. And I think there was also discussion about the fact that the thinking was that if the lockup wasn't given, you wouldn't be able to get the money that you got from Forsman Little. Looking back at that with hindsight, do you think there was some other way that the Revlon board could have proceeded to get more money without giving the lockup?
I really don't. If you take Forsman Little at its word, which the board had every reason to. In fact, they actually brought Forsman into the boardroom, if you remember looking at the record, Teddy Forsman, and flat out stared him in the eye and said, and tested him on this idea that he was going to walk, or he was going to. He was done if he didn't get everything he asked for, including the lockup. The other side's primary argument in the Supreme Court had been just the one that your question suggests. They were arguing you should have closed this auction by having a simultaneous sealed bid arrangement. But if Forsman wasn't going to bid, that wasn't going to get you anything. So I really continue to believe that that the Forsman deal was necessary in order, frankly, to get up to the 58 that they ultimately ended up with. And this is a strange case in the sense that the way it all worked out for stockholders was pretty good. I mean, they ended up with 58, and how else were they going to get 58? And part of that is the leverage that ended up being exerted. I won't say it's leverage exerted by the court, but the idea that that in the end, Pantry Pride was playing to the court when it went to 56, 25, and 58. In a way, the court was the other bidder in the end of the game, and I don't think anybody believes that there was any more on the table from anybody beyond the 58. Certainly not from Forsman Little, and there was nothing to cause Pantry Pride to go any higher, but that was pretty high under the circumstances.
Well, thank you very much for sharing your memories of this with us.
My pleasure.